Imagine a courtroom in the year 2026. The judge presiding over the case is, human, wearing the traditional robes, listening to the arguments.
Right.
But the clerk whispering in their ear, like rapidly drafting the case summaries and pulling up decades of obscure legal precedents in milliseconds.
And highlighting inconsistencies in witness testimony. Yeah.
Exactly. But that clerk is actually a black box algorithm. And that algorithm is owned and maintained by a private tech billionaire.
Which is a terrifying thought.
It really is. So
Yeah.
when you look at that scenario, the immediate question that hits you is, well, how on earth do you regulate a ghost in the machine?
Yeah.
How do you ensure justice isn't just quietly outsourced to a piece of proprietary code?
I mean, it is the ultimate modern paradox for any legal system. You're trying to build this rigid, reliable structure of law in order to contain a technology that is inherently fluid.
Right. It's constantly changing.
Exactly. It's often opaque, and it's evolving at a speed that traditional legislation simply cannot match.
Welcome to the Deep Dive. We are thrilled you're joining us today because we are looking at an absolute masterclass in solving that exact paradox.
We really are.
Our source material today is a detailed, highly technical commentary by Naavi. And, just for context, Naavi is a leading authority and expert on data protection in India.
Yeah, and Naavi has analyzed a freshly released draft from the Supreme Court of India. It's titled Regulations for Use of Artificial Intelligence in Courts 2026.
Which is currently out for public comment, right? So this
Yeah.
is the perfect time to dissect it.
Absolutely. And, this is not just some internal memo for the IT staff. It is arguably one of the most comprehensive, ambitious, judicial AI governance frameworks proposed anywhere in the world.
Okay, let's unpack this because the sheer scale of what the Supreme Court is proposing here is just, well, it's staggering.
It really is massive.
We're looking at a document featuring 57 distinct clauses, systematically spread across 10 distinct chapters.
Yeah.
When I was reading through Navi's notes, it struck me that this doesn't read like a simple checklist of best practices.
No, not at all.
It reads more like a highly detailed architectural blueprint for, I don't know, an entirely new digital civilization. So, looking at these 10 chapters, what stands out to you about how they've organized this massive undertaking?
Well, what's fascinating here is how the commentary explicitly notes that the draft is exhaustive. It is so meticulously structured that it's essentially ready to be enacted as a formal law in its own right.
Wow. Just on its own?
Yeah, they haven't just addressed the software itself. They've broken down the entire life cycle of the technology, anticipating problems before they even occur.
That makes sense.
So rather than walking through it chapter by chapter like a textbook, it helps to look at the actual mechanisms. You can sort of group these 10 chapters into 3 operational zones.
Okay, lay them out for us.
You've got the foundation, the engine room, and the safety net.
Okay, so let's start with the foundation because before you plug anything in, you really need to know where the boundary lines are. The source highlights that the early chapters 1 through 3, they don't just set up general principles. They explicitly define permissible and prohibited uses.
Right.
And that feels like a massive philosophical stake in the ground. I mean, in a typical corporate setting, a terms of service agreement might vaguely say, don't use this for illegal activities.
Yeah.
But here, the judiciary is proactively fencing off specific cognitive tasks.
They are establishing the ground rules from day one. And, that is absolutely vital in a judicial setting.
Right.
Defining a prohibited use means drawing a hard line that the algorithm just cannot cross, regardless of how advanced it gets.
So what's an example of that?
Well, for instance, an AI might be permitted to collate scheduling data or summarize a 1,000-page financial document. Those are permissible administrative assists.
Okay.
But the framework structurally prohibits the AI from weighing the credibility of a witness or determining the final legal culpability of a defendant.
Because, you can't put an algorithm on the stand and cross-examine it to find out why it decided a witness was lying.
Precisely.
If a human judge makes a biased call, there is a paper trail of human reasoning that can be appealed. But if a black box AI makes a biased call because its training data was flawed.
It just looks like cold, hard math.
Exactly. It's just a black box.
And by defining these boundaries up front in the foundation, they avoid the reactive trap of waiting for a machine to ruin a trial before deciding it shouldn't have been used in the first place.
That is smart.
Yeah, and once those foundational boundaries are locked in, the framework moves into what we call the engine room.
Right, chapters 4, 5, and 6.
Right, this is where the daily mechanics of the policy live.
So this includes policymaking, oversight, audits, and crucially, chapter 6, which covers procurement and private sector engagement.
Yes, very important.
And I actually want to spend some time on procurement because to a layperson, that sounds like the most tedious bureaucratic function imaginable. It sounds like, buying office supplies.
I know, it sounds dry.
But in the context of court AI, procurement is really the front line of defense, isn't it?
It is the gateway for every potential vulnerability. When a judicial body procures an AI system, they are not buying off-the-shelf word processing software.
No, definitely not.
They are frequently engaging with highly complex proprietary models developed by external private tech companies.
Right.
So the inclusion of private sector engagement right next to procurement is a stark acknowledgement by the Supreme Court of a massive security risk.
Because courts are repositories for the most sensitive, confidential data in a society.
Exactly.
It goes back to that scenario we opened with. It's like inviting a brilliant but incredibly secretive consultant to sit in on every closed-door trial, read every sealed document, and analyze every piece of protected evidence.
Yeah, it's a huge risk.
You need absolute ironclad rules about what that consultant can see, what they are allowed to remember, and who they report back to.
And how do you enforce that when the consultant is just a piece of code?
Wow, right.
That is exactly why Chapter V mandates rigorous oversight, audits, and incident management. An AI audit isn't a financial review, it's a technical stress test.
So they're looking for what, exactly?
It means actively checking the algorithm for data drift, testing the model to see if it has developed latent biases over time, and ensuring the private vendor hasn't created a backdoor.
Oh, a backdoor that funnels sensitive court data back to their corporate servers to train their next commercial model.
Precisely. Which naturally leads us to the final operational zone you mentioned, the safety net.
Okay, chapters 7 through 9.
Right. If the foundation sets the rules and the engine room runs the machine, the safety net is there to catch the inevitable human and technical failures.
Right, because things will go wrong. So this encompasses data protection, capacity building, and grievance redressal.
Yes. It recognizes that even the best procured system is totally vulnerable if the people using it are uninformed, or if there's no mechanism to fix a mistake.
Capacity building is a really interesting inclusion to me. It essentially means training and upskilling, right?
Yes, absolutely.
Because you can spend millions of dollars installing a state-of-the-art AI system, but if the judges and the clerks don't fundamentally understand how a large language model generates text, the tool is dangerous.
It's extremely dangerous. If you do not train the humans, you simply cannot have meaningful oversight.
Yeah.
A judge needs to be trained to spot an AI hallucination, where the system confidently invents a fake legal precedent.
Right. They have to spot that just as readily as they can spot a flaw in a lawyer's argument.
Exactly. And if a hallucination does slip through, well, that is why grievance redressal has its own dedicated chapter.
Let's explore the mechanism of that for a second. Let's say a citizen's case is negatively impacted because an AI tool incorrectly summarized a key piece of exonerating evidence, and the clerk missed it.
Okay, a worst-case scenario.
Right. The framework provides a predefined legal pathway for that citizen to halt the process, demand an audit of the AI's log, and seek a remedy.
Yeah.
So the accountability doesn't just evaporate into the cloud.
It's a marvel of administrative foresight, really. When you analyze the mechanics, the proactive boundaries, the rigorous audits, the capacity building, you understand why Naavi's commentary elevates this draft.
Yeah, it's so thorough.
But the architecture is only half the story. The true core of this document is the philosophy driving it.
Okay.
The source material specifically notes that this draft adopts a distinctly Indian approach to artificial intelligence.
And the commentary defines that approach with a very specific pivotal phrase. It says, AI is welcomed as an assistant to justice, but never as a substitute for judicial reasoning.
That is the anchor of the entire framework. It is a fundamental philosophical stance.
Right.
It asserts that the actual act of judicial reasoning, weighing human context, understanding intent, applying empathy, and interpreting the spirit of the law is a uniquely human endeavor.
I love that. But let me play devil's advocate here for a minute, because I think a lot of tech developers would push back on this pretty hard.
Oh, they definitely would.
I mean, Indian courts and, frankly, judicial systems all over the world are drowning in massive backlog.
Yes, millions of cases.
Civil cases can take decades to resolve. People literally pass away before seeing a verdict. So if we have an AI that is demonstrably 99.9% accurate,
Right.
an AI that could process millions of pages of case law and clear a 10-year backlog in a single month, well, isn't this distinctly Indian approach of forcing a human to remain the ultimate bottleneck actually a denial of justice?
It's a tough question.
Aren't we just preserving the tradition of the human judge at the expense of a citizen who desperately needs a rapid decision?
Look, it is a compelling counterargument, and it's exactly the tension between Silicon Valley tech solutionism and constitutional law.
Right.
But the framework stance is that speed cannot supersede constitutional safeguards.
Interesting.
An AI can process a million pages of precedent, yes. That is the assistant function, and it will radically speed up the preparation of cases. But an AI does not understand justice.
No, it doesn't.
It predicts text based on historical data. And, if historical data contains systemic biases, an AI will rapidly and efficiently replicate those biases at scale.
Oh, wow. Yeah, it optimizes for patterns, not for equity.
Exactly. When you cross the line from the machine summarizing the data to the machine making the final call, you violate the core tenet of the justice system, which is accountability.
Right.
A citizen has the constitutional right to be judged by a human being who is legally and morally accountable for that judgment.
Because you cannot penalize an algorithm in any meaningful way.
No. You cannot hold a server rack in contempt of court. The accountability must stop with a human wearing a robe.
It's a very sober, grounded way to view the technology, really cutting through all the utopian hype. The courts are basically saying, yes, we want the speed, we want the innovation, but this is merely a tool.
Exactly.
It's a highly advanced hammer, but it is not the carpenter.
That's a great way to put it. And by drawing such a definitive line in the sand regarding human accountability, the Supreme Court is doing something much larger than just managing its own courtrooms. The implications of these 2026 regulations extend far beyond the judiciary.
Well, here is where it gets really interesting. We are talking about a massive ripple effect across the entire country.
Absolutely.
Because the Supreme Court has just publicly published this 10-chapter, 57-clause masterclass in AI safety. They have effectively set a towering high watermark for everyone else.
If we connect this to the broader national picture, the source material explicitly states that this judicial framework will now set the baseline platform for AI regulations across the board.
Wow.
The commentary notes that whatever broader regulations the government was previously planning will now have to be reevaluated through the lens of this guideline.
Wait, really? So the government's own tech ministries are suddenly playing catch-up to the courts?
In many ways, yes. The judiciary has established a rigorous standard of care, even though, legally speaking, this draft is currently restricted to the operations of the courts.
Right.
Practically speaking, it is going to be viewed as an indicative due diligence standard for the entire private sector.
Okay, because this sets an indicative due diligence standard. Any private company, say, a bank using AI for loan approvals, or a hospital using it for diagnostics, that gets sued for AI malpractice is going to face a very specific problem.
Oh, a massive problem.
When they end up in court, the judge is going to look at the tech company and ask, did you act responsibly? Did you audit your systems? Did you define prohibited uses?
Right.
And if the tech company's internal safety policies are weaker than the 2026 rules the judge uses in their own courtroom, well, that company is going to have a nearly impossible time defending itself.
It is a brilliant indirect mechanism for regulating the wider ecosystem.
It really is.
The courts do not need to wait for a sweeping national technology law to be passed by Parliament, which can, take years of debate.
Yeah, forever.
By setting their own internal house rules so incredibly high, they force every private enterprise to level up their compliance just to avoid being penalized by those same courts later.
It is regulation by rigorous example.
Yeah.
And we are already seeing the practical application of this ripple effect happening in real time.
We are.
The source material mentions that data protection professionals are not waiting around. Naavi and the FDPPI, which is the Foundation of Data Protection Professionals in India, are proactively stepping up to integrate these rules.
Yes, the commentary highlights that they are already working on upgrading the existing DGPSI AI framework.
So for those listening who might not know, how does the DGPSI AI framework function in this context?
So the DGPSI AI is an established, comprehensive framework used by data governance professionals to audit and assess corporate compliance.
Okay.
It is essentially the tool experts use to look at a company
Yeah.
and determine if they're handling data and AI safely. What Naavi and the FDPPI are doing is taking the incredibly robust principles from the Supreme Court's 2026 draft. The strict procurement audits, the clear boundary lines, the incident management protocols,
Yeah.
and they are coding them directly into the DGPSI AI assessment structure.
Oh, I see. They are actively translating the Supreme Court's blueprint of justice into a practical checklist for corporate compliance.
Exactly.
They are taking that high watermark set by the judiciary and building a ladder so the private tech sector can actually climb up and reach it.
Precisely. They recognize that the Supreme Court has just handed the country a gold standard for AI governance.
Yeah, why reinvent the wheel?
Right. Instead of waiting for a legislative mandate, these professionals are adapting the judicial principles for immediate voluntary use in the private sector. It really demonstrates how judicial foresight can rapidly accelerate industry-wide best practices.
It really flips the usual narrative on its head. I mean, we're so used to the story being that the legal system is always 10 steps behind technology, constantly scrambling to figure out what a new app does.
Usually, yeah.
But in this case, with the 2026 regulations, the judiciary is arguably stepping out in front. They are setting the pace, establishing the boundaries, and demanding that the technology conform to human constitutional values.
Rather than reshaping the law to accommodate the technology exactly.
Yeah.
Which is the fundamental purpose of a constitutional safeguard. It exists to protect the core values and rights of a society against shifting tides, whether those tides are political movements or technological revolutions.
Beautifully said. So, bringing this all together for you listening, whether you are a software developer writing these models, a corporate executive deciding how to integrate them, or just an everyday citizen wondering how algorithms are going to impact your civil rights.
It affects everyone.
It does. This 2026 framework is a massive, incredibly detailed signal. It tells us that the future of AI governance, at least under this distinctly Indian approach, isn't about surrendering our agency to the machines.
No, not at all.
It is about building complex 10-chapter safety nets. It is about ensuring that no matter how sophisticated, how fast, or how seemingly brilliant the artificial intelligence gets, human accountability remains the absolute, unquestioned king of the courtroom.
It is a profoundly human-centric approach to managing a non-human entity.
It really is.
However, as we examine the long-term implications of this framework, it raises one final, highly provocative question for us to consider.
Oh, what's that?
Well, the draft strictly designates AI as an assistant to justice, ensuring the human remains the ultimate decision-maker.
Right.
But what happens practically over the next decade when that assistant becomes undeniably efficient? What happens when the AI proves to be right 99.9% of the time?
Oh, I see where you're going with this.
As the years go by, how do we ensure that keeping a human in the loop doesn't just devolve into a tired human, thoughtlessly rubber-stamping an AI's brilliant work?
Wow, that is a scary thought.
Right. A 10-chapter framework can mandate that a human judge must sign the final order. But how do we legislate active critical thinking in an age of perfect assistance?
A vital question that we will all need to keep our eyes on as these systems roll out. Thank you so much for joining us on this deep dive. Keep questioning the systems being built around you, keep an eye on how these frameworks evolve, and we will catch you next time.